All right, Judge, may I open court?
Yes, please.
Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-5182. Cause of Action Institute, Appellant versus United States Department of Justice. Mr. Mulvey for the appellant, Mr. Ross for the appellee.
Thank you. Good morning. Mr. Mulvey, you may proceed.
Good morning, Your Honors. May it please the court. My name is Ryan Mulvey. I represent Appellant Cause of Action Institute, and I intend to reserve 1 minute for rebuttal. This case presents the unresolved question of the meaning of a record under the Freedom of Information Act. In American Immigration Lawyers Association versus Executive Office for Immigration Review, this court ended the longstanding practice of scoping records, that is, redacting portions of a record considered non-responsive by agencies. But agencies have adapted, and they now seek to segment unified records into smaller records, which can then be withheld as non-responsive. That approach, exemplified in OIP's 2017 guidance and applied here to the QFRs at issue, depends on misguided dicta from AILA to advance a subjective ad hoc definition of a record that conflicts with the text of the FOIA and with common sense. There are 4 broad reasons why the government's position is wrong and its treatment of the QFRs is incorrect. First and foremost, Congress has added a definition of the FOIA, of record to the FOIA. Appellant has set forth a 4-part, 4 elements to that definition that logically follow from the 2 clauses at Section 552 F2, or more specifically.
Mr. Mulvey, can I pose 2 or 3 hypotheticals and wonder if you think that they're records, if they're a single record or if they're multiple records? The first one is of let's say the January volume of a law review. So it's bound in 1 volume. It's consecutively paginated, but each article is different and each article is by a different author. Do you think that that's one single record, or do you think each article is its own record?
If the bound physical copy of the law review, we're not talking about PDFs of the individual articles, the entire volume would constitute a record. Whether or not it would be subject to disclosure as falling under agency control, I think is an important question.
Right. No, I'm just trying to probe the meaning of record.
Sure.
What about the transcript of a trial? Do you think, you could imagine that each day's transcript that the court reporter types up is a record? Or you could imagine that the whole thing, let's say it's a 2-month trial, the whole 2-month trial is one record. So do you think that's one record or multiple records?
Your Honor, I think that would depend on how it's being maintained by the agency. So in my own practice, for example, transcripts are usually based day by day. You have separate PDFs that come from the reporter. If those separate PDFs are being maintained separately by the agency, then each of them are records. If the entire trial has been turned into a single PDF, then that would be a single record.
Do you think it would depend at all on how the FOIA requester phrased the request? So let's say FOIA requester number 1 says, I'd like the trial record, and FOIA requester number 2 says, I'd like the record for May 2nd of that trial. Do you think that the nature of the record would be different in the first request from the second request?
I don't think that the nature of the record would be different, but I think what's interesting about the second hypothetical you pose is that it does contain a sort of implicit consent to exclude portions of the record for purposes of processing the request. And I think what would be most appropriate then in that situation is for the agency to communicate with the requester and to confirm the consent to exclude portions of the complete transcript that the requester is not interested in.
Is that
I'll lay off the hypotheticals. I'm done.
So Mr. Mulvey, I guess I have maybe a related question to that, which is, does it matter if the requester, so some types of requests say, I would like the trial transcript of this day, right? And so that is arguably something that exists in some form. Other requests seek information about particular subjects. I think perhaps like your request, cause of actions request in this case. So, does the agency think about records differently with those two different types of requests? Some requests are for specific documents and some are for specific subject matters. And in the latter case, under the Aaliyah decision, I mean, might it not be appropriate for the agency to then define the record in relation to the subject matter that is being sought by the requester?
I think those considerations come in not at the point of responsiveness review and defining a record, but in terms of designing a search. The subject matter of a request is helpful when an agency constructs its search methodology and attempts to locate potentially responsive records. It doesn't come in so much at the next stage of defining a record. And in fact, I'd like to point out that this actually raises a very interesting aspect of the AILA decision, of the dicta on defining a record, which is that the AILA court seems to have missed a step in the FOIA process. So after dismissing the existence of 552 F2 and describing it just as a description of records, the court says, well, responsiveness review seems to be the first step, so agencies can define a record at that stage. But it misses the search. Before responsiveness review, before application of a control test, before consideration of exemptions, an agency collects a universe of potentially responsive records, things that exist as maintained by the agency at the time of the request. The things that get returned from a search, Word files, Outlook messages, Excel sheets, PDFs, those are records. Those are existing objective things already at the agency. There really shouldn't need to be any further investigation of the subject matter of the request in order to break up things. I mean, that's all. The government's position here is really just a policy-based argument that's better directed at Congress. It doesn't grapple with the text. It doesn't really grapple with how the FOIA process actually works.
But
I understand your. Oh, I'm sorry. Go ahead. Go ahead.
No. Oh, I guess I wonder if what you just stated about a search, right, is in some ways an artifact of the fact of our ability now to do detailed electronic searches of documents, right, where many documents might come up with, just a couple of search words in it. Whereas, when FOIA was originally drafted, I mean, records were probably things that in fact existed as discrete documents, and there would be a search through some paper archives, for responsive documents. In a world of electronic searching, I wonder if that is really a reasonable way to think about records.
Well, Your Honor, if anything, I believe the fact that we're in an electronic world makes the application of an objective definition of a record even easier, precisely because you're dealing with, for example, PDFs. It's very clear on a computer to see what exists as a discrete file, whereas with paper records, that can be a little more difficult, as I think some of the case law and certainly older case law has dealt with. But to return to the reasons why the government is wrong here, I mean, beyond the existence of a statutory definition that the government doesn't even attempt to ground its position in, it offends the government's position in the treatment of the QFRs here, offends common sense. I think the district court in Lipton described very well that the ordinary understanding of a record is that it is an existing document or other permanent preserved account of past events. It has to exist prior to the submission of a request. With respect to the Privacy Act, I think the briefs address this very well. I would just like to point out this circuit's decision in 1983 in McGehee versus CIA, footnote 47, where this court said that the Privacy Act definition of a record is, quote, not germane, end quote, to the FOIA context. I think that pretty much resolves any sort of attempt to use a portion of the Privacy Act definition of a record. Cause of Action in its briefing presented a number of principles related to the idea of the preexistence of records prior to the submission of a request. In most part, the government didn't answer any of them.
There are two crucial things, if I'm understanding you correctly, two crucial points that you're making underlying your argument. One is that you've already mentioned, that is, a record exists before the requests are made. I think that's certainly been my understanding. The agency is looking for records in which they might find the relevant information. And the other point, if I'm hearing you correctly, an information is not a record. And that seems to be lost. Information may be contained in a record, but information is not a record. It is simply communicable knowledge that may or may not be in a record. Am I understanding you correctly?
Yeah, I think that's right, Your Honor. I would say that this came up in the government's brief, and we addressed it in our reply brief, where we said that a record contains information, but the existence of a record is not conditioned on the subject matter content of the information.
No, I understand that point. But I think you're trying to make the strong point that or strong for you, that the record exists before the requests are made, and the government is now searching for the information that is being requested in the records that already exist.
In the record, yeah, in the format of records, correct.
In the format of records, because that's what the statute says. We're talking about records. We're not talking about searching for information, although they're certainly looking for information, but the statute causes them to look for the information in the records, is your point, right?
Yes, Your Honor.
Okay.
Mr. Mulvey, is that definition of record consistent, though, with AILA's language that this is, I guess, on page 678 of the case. Under FOIA, agencies in effect define a record when they undertake the process of identifying records that are responsive to a request, right? Which suggests that the record is in part defined in relation to what is being sought after.
Well, Your Honor, I think our point is that Section 552 F2 doesn't actually say that. And
Right.
then this aspect of the dicta in the AILA court there is no legal authority for it. And I'm not quite sure where it comes from, but it's wrong, precisely because, as I explained before, it misses the initial step in the FOIA process, which is before a responsiveness review is conducted, which is what this line, I think Judge Srinivasan was contemplating. A search is conducted and potentially responsive records are compiled to be processed for responsiveness control and statutory exemptions.
Well, so in a situation, if that is true, though, how are we supposed to parse whether, I mean, say in the facts of this case, not even a hypothetical, whether the QFers are all of the QFers taken as a whole, or are individual questions for the record?
Well, here, Your Honor, the agency's declarant conceded that the QFRs existed as a single document and were transmitted to Congress as a single document. It argued basically a coulda, shoulda, woulda type of argument that, well, we only created one record for efficiency's sake. Well, that may be the case, but the agency created one record, maintains it as one record, transmitted it to Congress as one record, and identified it as one record responsive to cause of action's FOIA request, and only decided to break it up after the fact. And then maintain that position after an administrative appeal where cause of action clarified that what it sought was the entirety of the QFRs as they exist at DOJ.
But that wasn't the request that cause of action made, right? Presumably cause of action could now make a request, for all of the questions for the record from a particular day to a particular executive branch official.
Well, cause of action could always, yes, submit a new request. Part of the government's argument, though, is that that shouldn't be necessary. It talks about the importance of communication between the requester. The government believes that cuts in favor of DOJ's position, but in actuality, it cuts the other way. Because that there was communication in the form of an appeal, somewhat more formal communication than might otherwise occur, but cause of action clarified what it was actually seeking. Cause of action had no reason to suspect that DOJ would split up the QFRs the way that it did because it was concerned about efficiency, or because I believe at one point the government claims it didn't want to confuse Cause of Action Institute by releasing material that wasn't related to what it understood to be the subject matter of the request. But that gives agencies such broad discretion to determine what's going to be useful, contextual information to a requester. It's one thing if the agency wants to reach out to the requester and negotiate a narrowing or an exclusion of certain portions of a record, but to just give the agency full discretion to treat a record any way it wants for the sake of efficiency.
In this context, though, the questions for the record, some of them are very distinct. Your request was about earmarks, right? And so say a question about Guantanamo Bay, how is that responsive to the request that cause of action submitted?
Well, what's responsive isn't subject matter content within the record. The record in its entirety is what FOIA contemplates as being disclosed. And when you're doing a responsiveness review, you look at the entirety of the record, and if any portion of it is responsive, then the entirety is responsive. In terms of the government, if what you're thinking, Your Honor, is about the government's argument that certain subparts of questions or certain questions in the set of QFRs weren't directly related to earmarks or the decision to obligate agency funds, well, that information still has valuable context because it gives cause of action an idea of how DOJ approached one subject matter within the same set of QFRs as opposed to another. It may have given short shrift, for example, to agency decisions to obligate funds as opposed to Guantanamo Bay.
Let me ask you another question. So if, so these were all compiled into one document. I assume maybe somewhere at DOJ, these also exist as separate documents. So if they released the Word files that were just for particular questions, would that be also a record?
Yes, Your Honor.
So in my experience in the executive branch, often, these questions are divided up and then they are recompiled. So if they just gave you the separate documents and not the compilation, would that be inconsistent with FOIA?
Yeah, so as the record demonstrates, and I addressed this in our briefing, the agency could have, so it receives the questions from Congress, it breaks them up, sends them to different components, and then recompiles the responses. The agency could have tried to look for the final responses from the different components at DOJ, which represented final responses, but before they had been compiled to create a new record. And those could have been processed in response to cause of action's FOIA request. But DOJ didn't choose to process those records. Either it didn't find them.
It's just an accident of how things are placed into combined Word files or PDFs. Is that, is it just that's almost accidental in a way, or created for efficiency or record keeping?
Well, I wouldn't describe it as accidental. This is just a reality of how records are created in an agency. The problem isn't unique. It's not really a problem, but the situation is not unique to QFRs. I believe it was the district court in American Oversight versus HHS, for example, when it was talking about email chains, and it explained in a footnote that with each email chain, with each response that comes, this was in a footnote because it wasn't exactly on point to the holding of the case, but each act by an agency employee to create a new chain creates a new record that incorporates the previous conversation. So you're going to have a lot of duplication, and in a sense, it's an accidental creation in the same way that Your Honor is proposing with QFRs. But the fact remains that each of those email chains is a separate record. Each is potentially subject to records management obligations under the Federal Records Act, for example. And each can be processed in response to a FOIA request. So I wouldn't dismiss the fact that there exist component level records that are responsive as somehow dispositive as to the treatment of the compiled complete set of QFRs that were transmitted over to Congress. My time has expired. Thank you, Your Honors.
Do my colleagues have any further questions?
No, thank you.
Yeah, okay, thank you. Mr. Ross?
Thank you, Your Honor. Good morning. May it please the court, Kason Ross for the Department of Justice. As Your Honors have explained previously, plaintiff here sought information under the Freedom of Information Act concerning government spending on various earmarks, including grants to various Justice Department programs. And among the material identified was questions located in those records, or answers to various
you were
questions.
right. Your answer was right, in those records. That's exactly the point. That is exactly the point. Let me tell you my concern, just so you can have it in mind.
Sure.
The government seems to be saying that you define requests, as you just started doing, except you slipped and you said what I think is appropriate. You're defining requests by reference to the information sought. Then when you find the information, you delete anything in the same record that's not responsive. I don't know where that comes from. That's simply not what FOIA says. FOIA refers to records. You're not you're really searching for records in which information is contained. And you seem to be treating the two as if they're one and the same. They are not. Definitionally, they're not the same. Information is just communicable data. Creating a record is something different, and having a record, and records include information. And I think your approach smacks directly in the face of what the court held. You can't go to a record and then delete pieces of it that you identify as being non-responsive. And that's what it seems to me you're doing. I thought this was one of the sillier and simpler cases, and I can think of a lot of them that would be really hard. But you have here, you have a document with a title, questions for the record. That is, questions that are in the record is the way I read it. That's the title of it. One title, successive pages, questions and answers that are numbered successively, all within this one document. If that isn't a record in the minds of most people, I don't know what is. And it looked utterly bizarre as I was reading the appendix to see you're knocking out information in the record that you say is non-responsive. You have no legal basis, and that is exactly what the court said you could not do unless it was exempt information.
That's correct, Your Honor. But the government's position in this case is not that we took a single record and redacted information, rather that there were many records within a set of questions for the record.
Well, that's self-serving, and I know we can go in circles on this, merely stating
Sure,
to make it so. In other words, I have this picture of this document that you created that has a title covering it all, refers to itself as a record, including all these questions in that record. That's your title. I didn't make the title. It has successive pages, and the questions within that single record are numbered successively. And I don't know how that can't be a record.
Your Honor, it bears emphasizing in this case, and perhaps I can draw an analogy from Judge Walker's hypothetical about a law review volume. The questions for the record in this case were submitted by various members of Congress, multiple senators and multiple representatives. And it's as if each of those questions is like a law review article. Of course, the question and answer is much shorter than a full law review article, but the same concept applies. That is, whereas the volume of a law review article, of a law review issue, which contains multiple individual articles, it strains understanding why a single volume, which contains multiple articles, would be a single record, when if each of those records was published individually, would be a single record. Plaintiff's own analogy in the reply brief compares a physical binder of multiple documents, as compared to an electronic, that is, if that binder was electronically transmitted as a single PDF. Whereas the physical binder of the exact same information would constitute multiple records on plaintiff's reasoning.
My request says I want all the records in which Judge Walker has published articles.
Then each of the articles would constitute a record.
Right. I want all the records in which Judge Walker has published articles. That would be the whole book. You can't make the judgment about whether the rest of what's in that record they should or should not be looking at. I was really kind of blown away that this was even a question. Now, that may just show my age, but I never saw this in the old days. And that doesn't win a case, but it's to let you know why I'm flabbergasted. This is so straightforwardly a record in my mind, I can't find a way to make it other than a record. What you put in the record, in the appendix, that is so straightforwardly a record. And what you've done is take pieces of information out of an obvious record because you don't think it's responsive to what they're really looking for. And we've already said you can't do that.
So, Your Honor, I think that the government's position here is rather that a record as a unit is defined by the information of which it comprises. Judge Rao's line of questioning with plaintiff's counsel is elucidating here, namely that if the government had instead identified various Word documents of each of the individual files, plaintiff, to my mind, conceded, or acknowledged rather, that each of those individual Word documents would have constituted a record. It's simply by virtue of the fact that information here was transmitted between branches of government for sakes of efficiency.
Well, you know, the more interesting question would be to take Judge Rouse and extend it and see what and I can suspect what the government wants to do. Take each one of those Word documents, you would have found them as a record, and then you would have gone through each paragraph and deleted each paragraph saying, those paragraphs are not really responsive to what they're looking for. That's exactly what you cannot do. So, I mean, Judge Rouse's question, I think, is perfectly apt. The record is the Word document. And what I'm saying to you is you can't now go through that record and delete pieces of it because you don't think it's responsive to what they're really looking for. That makes no sense to me.
I understand, Judge Edwards, and I think that the government's position here is rather that we're not deleting, the government is not deleting portions of a record. Rather, we're defining record according to the nature of a particular request so that it's responsive and is able to efficiently provide information that the government has.
Information, that's where you are trying to build a bridge between information and records that I think you cannot do definitionally. They're different. Information of all sorts can be contained in a record and they may not be related to each other. It doesn't make the record any less a record because the pieces of information in it are not obviously connected. That's your premise, and I don't get it. I looked everywhere, and I find no one suggesting. Now, the government can have a record system that says, let's not ever have records that include information that are not related in some way. That's fine if you do that, and that's clearly the way you set it up, then it's a different case, but that's not what we're talking about here. You created this record.
It bears noting, Your Honor, that this court has reiterated multiple times that the focus of FOIA is information, not documents.
Oh, no,
and
no,
so,
no.
No, that's directly from this court's decision.
FOIA by words of the statute are records. And that's exactly, counsel on the other side is exactly right. You're searching for records in which you'll find information. You have conflated the two, and that is simply wrong.
So, Mr. Ross, oh, sorry, go ahead.
No, please go ahead, Judge Rao.
So I guess my question is, I mean, the OIP guidance, the Office of Information Policy guidance here seems to distinguish between two types of requests. One is a request that identifies a record itself that may exist as a record. And the other is requests that are for particular forms of information that, of course, would be found in records, but that don't necessarily describe the records themselves. And it seems to me that the OIP guidance treats those two types of requests differently. And I'm wondering if you can explain what the justification is for that different treatment.
Your Honor, I think first I'll start by noting that guidance was released in response to this court's decision in American Immigration Lawyers Association, and was an effort to provide guidance, and it's not legally binding, but is an effort to provide guidance throughout the government as to how to efficiently respond to FOIA requests. That said, there may be situations in which a record can be defined agnostically, platonic to a particular request, and other circumstances in which a record is more correctly defined in response to a particular request. And it bears emphasizing in an effort to fully satisfy what a FOIA requester is seeking. So, for example, here, it would be one thing if a FOIA requester, as plaintiff's counsel was adverting to, requested, for example, all questions for the record in response to Attorney General holders sitting before Congress in April 2010. Plaintiff's counsel seemed to suggest that the government may have treated different different questions from members of Congress differently. And in order to suss that out, plaintiff should have requested all of the questions and answers in response to Attorney General Holder's appearance. And as the government has explained in this case, we would have disclosed that information, possibly as a single record. But in this particular case, plaintiff had requested material on a specific subject matter, government spending on earmarks and pursuant to a specific executive order, and the government provided responsive material, in fact, all responsive material, and plaintiffs don't challenge that.
But you're supposed to give them a record. not responsive material. You're making the point over and over again that is legally wrong. And that's what our case says. You are supposed to turn over a record and you can exclude anything in that record that is exempt. You're exactly right. You're supposed to turn over the record, and you keep going to the point, because I know this is what you're doing, and it's flying right in the face of what we said. You now think you've looked for the information, you find it in records, and then you start deleting debate based on what you think they really want. That's not what FOIA has ever been intended to mean. That's not FOIA. They're entitled to everything that is in that record, even if you, the government, don't think they really need it.
We have never previously, though, defined precisely what constitutes a record.
Yeah, no, I understand, Judge. I certainly understand.
And I will just suggest, Your Honor, that this court in American Immigration Lawyers Association and multiple other cases explicitly said that FOIA doesn't define record. Section 552 F2, says what an agency record comprises, but that is meant to constitute the universe of agency records, which are subject to a search in the first instance, which is the subject of cases such as Department of Justice v. Tax Analysts and Kissinger v. Reporters for Freedom of the Press. This case instead asks a different question. What is a unit that comprises a record? And FOIA provides no guidance in that respect. And the government in this particular case has sought to explain that what that unit is in reference to a particular FOIA request.
I have one question about the record in this case. There's a series of questions from Senator Feingold that are not consecutively paginated with the other set of questions that were answered on that same day. Do you happen to know if it's in the record, if a declarant has said this? Were the Feingold CUFERs sent as a separate attachment when DOJ emailed its answers to the committee?
Frankly, Your Honor, I really don't know.
It may not matter.
I don't know. I'm sorry.
That's all for me.
Well, Mr. Ross, if you could just say, I mean, it sounds like the government believes it's entitled to, some type of leeway in defining a record. And I'm wondering where the government finds support for that position.
It's not leeway, Your Honor, rather that the government is seeking to efficiently provide FOIA requesters with the information that they seek. That's what we attempted to do in this case and in other cases.
I don't know why you keep arguing efficiency. Why is it more efficient to someone to be given the assignment to now go through this thing that we picked up very quickly, and here it is, a single document, and rather than turning that over, you now say, now go through and let's try and figure out what they don't want. That takes a heck of a lot more time.
So, Your Honor, that's incorrect. When the
Which
government
is incorrect?
I guess I'll just take a step back for a second.
Okay.
When the government receives a FOIA request, the determination of what constitutes a record and what is a responsive record is a fairly straightforward inquiry, and can be done by subject matter experts in the particular agency, in this case, the Office of Information Policy, and those records can then be determined or considered for processing. That is, for whether any of the material in those records should be kept exempt or not disclosed under the FOIA exemptions. Now, the decision whether to withhold material pursuant to a FOIA exemption is not one the government takes lightly and requires consideration of many different stakeholders. Many government equities must be considered in whether to invoke a FOIA exemption, and it would create a huge backlog, essentially, for the government to process much more material in response to a specific FOIA request, which hurts not only the FOIA requester in that particular case, but all other FOIA requesters who then have to wait that much longer for the government to process a substantially greater volume of information.
I'm really not following you, because I'm just use the material that we have in this case in the appendix. You pull out that one, what I'm calling a record, that has all the questions and answers on a single title, single pagination. You pull it out, you're done. Assuming there's no exempt material in it. There's nothing else you have to do. The information in it, responsive or not, is not the inquiry, and you will not be wasting time trying to figure that out. You just pull out that document, which is a record, self-evidently a record, and you hand it to them.
Apologies, Your Honor, but what I'm trying to explain is the decision of what constitutes a record is a fairly easy one to make, right. Whereas the decision whether that must be done, which is to process that information and determine whether to invoke the various FOIA exemptions, is a very difficult decision to make. And under Your Honor's understanding here, processing these particular files would have taken a substantially longer period of time just for the government to be able to determine which exemptions to invoke. And if the government chooses not to invoke an exemption, of course, that's waived for perpetuity. Once the government discloses something publicly, it can no longer invoke a FOIA exemption in subsequent cases. So all I'm trying to say is that there's a substantial daylight between determining what a record is and whether to invoke any FOIA exemptions within that record. And so that's why the government's position here is rather to identify responsive records according to a particular FOIA request and provide that information to a FOIA requester. If other information is sought, the FOIA requester.
Maybe I'm being dense. You identified this total record. And then what you did was go through it, and you did two things. One, I understand, always takes time. What's exempt, what's not. And then you spent additional time in that one record deciding what you thought was non-responsive, and you spent all that time crossing that material out, which the law does not ask you to do. But you agree it was a record. It was a record when you found it, and that when you did two things, you looked for exempt material, and then you looked for what you thought was non-responsive material. And that's inconsistent with the law of the circuit.
Apologies, Your Honor, but that's simply a misapprehension of what was done here.
I'm just looking at what you turned in. So obviously it's what was done. You found that record, obviously, because it's there.
We found multiple records, Your Honor.
Okay,
and we disagree with that.
Just take one for ease of conversation. You found that record. And what you and I are now talking about is what you do when you find that record, which you know has some of what they're looking for. The law says you give them the whole record. You said, no, we're going to go through the record, see what's exempt, if anything. And then additionally, we're going to take the time to go through that record again to see what pieces of it we're going to take out because we don't think it's responsive.
Well, I guess in part the question is, when you have a document, who decides whether that document is a collection of records or whether it is a single record? And my understanding is here, when you located the questions for the record, the government determined that that was a series of records that were compiled into one document instead of just a single record.
Correct. And so the government's position is that in response to a FOIA request would identify those particular records to satisfy that FOIA request. And that decision is subject to judicial review, just as here.
Right. Who would ever file? I mean, I'm finding it very funny because it makes no sense to me. Who would ever file question one and the answer to question one as a record? What business and what government agency? Oh, go look in file 22 and you'll find question 3 and the answer. That's a record in there. Under what record filing system would anyone do that? It makes no sense. I understand there is this difficulty in defining precisely what is and is not a record, but there's some things that seem to me are so clearly not records. And I don't understand conceptually how you think any normal person would handle question 3 as a record and go file it because there's record management. Where do you put it as a record? It's make it rhetorical. I'm just letting you know so you understand my concern. I don't get the position, and it looks like it's inconsistent with what we said.
To get some clarification on something you said earlier in response to one of Judge Edwards' questions, the order that DOJ would have gone in, you could imagine them taking out everything that's exempt, which is time consuming, and then taking out everything that's not relevant in their opinion. Or you could imagine them doing it in the reverse order, taking out everything that's relevant, which is probably a pretty quick exercise. And then the universe of things that are relevant and therefore need to be subject to the exemption inquiry is a much smaller universe, which would actually make this process probably faster than if you had to go question by question and figure out for every question, does an exemption apply? Now, that doesn't mean that you're right about the statutory meaning or the meaning of the statutory term record. But if our only goal were to make things as easy as possible for DOJ, as fast and efficient as possible, am I right that it would depend on what order you go in?
So far as I understand your question, Your Honor, that's correct. And this court explained in American Immigration Lawyers Association that relative process. That is, first, the government sets forth the relevant information, and plaintiff's counsel went over this as well. And after identifying those responsive records, will process, so quote unquote, process them, meaning invoke particular exemptions for line items or specific information within those records.
Alex,
But if
I have nothing more.
we ask the court affirm, thank you.
Thank you, Mr. Ross. Mr. Mulvey, we'll give you an additional minute, or I think you asked for 1 minute. Well, that's fine. Yeah, 1 minute.
Would you mind starting very briefly with, if you know the answer to my original question, is there something in the record, and a declaration, an affidavit or something that gives me some insight on whether that the Feinstein document was sent as a separate attachment from the other consecutively paginated questions?
I don't believe that there's anything to that effect in the
Okay.
record. As I understand it, the record reflects that it was sent together, but I checked the appendix, and Your Honor, you are right that those 2 pages are not paginated along with the preceding pages. But I think the record is unclear. I just have 5 quick points in response to what government counsel discussed with Your Honors. First, Forsham v. Harris, 1980, very, very early in the FOIA's history, this court explained that FOIA provides access to records, not information in the abstract. It's true that there's never been a court that's addressed the precise definition of a record until now at the appellate level. But I think that's because, like Judge Edwards suggested, it's just common sense. We don't need a judicial decision on what a record is, because it shouldn't be subject to such a convoluted approach as set out in the OIP guidance. With respect to government counsel's suggestion that there's case law saying that there's no definition of a record, most of that case law doesn't, in fact, all of it except for AILA, says there's no definition of agency record. An agency record is a distinct concept from record. Finally, Judge Edwards, there's a maxim that I like, which is that the FOIA requester is the master of a FOIA request, but the agency is the master of its own records management program. It decides how to maintain records, but once it decides to create or obtain and maintain a record in a particular way, that is the record. And then finally, again, all that the government offers are policy-based efficiency concerns. Obviously, application of the OIP guidance and this attempt to define records after you've identified something that's possibly a record but not actually a record, that's convoluted. It's not straightforward. We wouldn't be having this case if it were so easy as the government contends. I don't understand the efficiency concerns, because whether or not you're segmenting a record and determining whether it is a record under OIP's guidance or that it's exempt, you're taking the same amount of time. And if there's no further review by superiors as to the segmentation of a record, that's deeply concerning, because that is as important a consideration as the application of statutory exemptions. It also conflicts. Sorry, Your Honor.
I think that we have your argument.
Okay, we asked that this court reverse. Thank you, Your Honor.
Okay, thank you, Mr. Mulvey. The case is submitted.
Thank you. I was. Oh, yeah, well.
Case number 20-1117, Transportation Division of the International Association of Sheet Metal, Air, Rail, and Transportation Workers et al., petitioners, versus Federal Railroad Administration, and United States Department of Transportation. Mr. McKinley for the petitioner, Ms. Mundell for the respondents.
Good morning, Mr. McKinley. You may proceed.
Good morning, and may it please the court. Sean McKinley, I'm representing the petitioners in this case, International Association of Sheet Metal Air Rail Transportation Workers, Brotherhood of Locomotive Engineers and Trainmen, and the Academy of Rail Labor Attorneys. This is a case where the petitioners are seeking a review of a federal agency rulemaking. In this case, this is the agency in question is the Federal Railroad Administration, and the rulemaking had to deal with so-called risk reduction programs, which are mandated by the Rail Safety Improvement Act of 2008. And now, when the FRA has broad authority granted to it by Congress to oversee safety concerns in the United States rail transportation system. That extends to rulemakings. The FRA is the body that's primarily responsible for rulemakings in the railroad industry in the United States. Now, this broad authority, though, is not limitless. The FRA is limited by, the mandates from Congress as expressed through various statutes. In this case, the limitations on the FRA's authority is limited by the Rail Safety Improvement Act, as mentioned, and also the Administrative Procedure Act, as this is a formal notice and comment rulemaking, as that is defined under the APA.
Mr. McKinley, let me start, if I may, with a couple of questions about your standing and maybe about remedies, and there may be some overlap. One of your arguments is that we should vacate the rule because it was tardy by about 11 years or 4 years. It was very late. And I would take it to be that your injury for Article 3 standing purposes is, well, there was this gap in time when the rule should have been in effect, when a rule should have been in effect, and it wasn't in effect for that gap of time. And we were injured because I guess a rule would have been better protecting you in terms of safety. But in terms of redressability, we can't go back in time. And so I'm not sure how vacating the rule or even just remanding it without vacating it with regard to the tardiness would do anything to redress the injury you suffered of going those 11 years or 4 years without a rule in place. So can you help me with that? How is this, with regard to the timeliness claim, how is this a redressable injury?
Well, thank you, Your Honor. I guess to answer that, I would say that the Congress and the FRA's own regulations, as you kind of intimated, require that the FRA complete rulemakings within 12 months from the date that the NPRM is published in the Federal Register. And as far as just to get us directly to your question, the first NPRM was issued in February of 2015, where the final rule was promulgated in February of 2020. So we're talking about a 5-year gap there.
It was supposed to be done in a year. So let's say that there was a 4-year gap where you were injured because a rule was not in place. How is that injury redressable by this court?
Well, I would define the injury a little bit differently, Your Honor. I would define it as the process for the rulemaking is 12 months, as we said. During that process, the FRA is required to solicit and receive public comments. It's an active process with the public and stakeholders in the industry. In this case, the FRA had accepted rule comments in April of 2015 through essentially October through a few different rounds of comments, and then did nothing for 4 years. And I think
you file an action seeking to compel the agency to complete what they're supposed to do. I mean, if we followed your approach, do you know how many things we'd vacate? Agencies are rarely on time. But to add to what my colleague is saying, it doesn't make sense intuitively. How is that giving relief? What do you want us to do? Just vacate and say, go away? You can't do anything now?
Well,
do it promptly or what? What are you saying?
Well, I would say vacate, and if the FRA to the NPRM can be reissued and they can complete the rulemaking within a year.
It's still late.
I'm sorry, Your Honor?
It's still late.
Well, this particular final rule is late, but if the FRA presumably restarted the process, they would have 12 months then to complete the rulemaking under 49 CFR 211.
You commented, right? During the notice and comment period, at least some of these petitioners did file comments. Is that right?
Yes.
And so is there something that happened as a result of the delay from a procedural perspective, from a, not that due process applies, but from a procedural, is there something that happened procedurally that went wrong that you think would go right if we vacated and remanded this and did it all over again?
Well, I think as I was getting to before, I think the issue is that the FRA was acting on information that was 4 years after it was submitted. This is an industry that changes from year to year. Technology changes, safety concerns change year to year. The FRA's final rule here is based on stale information at this point, stale comments from 5 years ago. And
Can you be specific about that in a way that's specific enough to give me something to go on?
Well, certainly, I guess, for example, I would say part of the Rail Safety Improvement Act was the implementation of positive train control technology. It's essentially a technology that is an additional safeguard on trains that permits if a train misses a conductor engineer miss a signal, the train can enter into a stop, like an emergency stop or something like that. This technology.
There was information that was not available at the time that's available now. But if the rule had been promulgated earlier, you still wouldn't have known. You still wouldn't have been promulgated based on the new rule. I guess that's another way of saying is, if the information between 2015 and 2016 is now stale, the rule, had it been promulgated in 2016, was still going to be promulgated based on that stale information, even if it had been promulgated on time. So I'm not sure I'm with you there. You can respond to that, and if you would also respond to this, you put a heavy emphasis on vacating as opposed to just remanding, not just for this claim, but for the fatigue management claim as well. Is your position that you want us to either vacate or do nothing? Is your position that a remand is not acceptable to you?
I wouldn't say not acceptable. I would say the law requires, under the APA, Section 706 of the APA, just that requires that the agency action be set aside.
But this court has precedents about when to vacate and remand versus when to just remand without vacating, and we look at how disruptive would it be, and we look at how bad, how wrong, how easy to fix it would be the original rule that has some problem in it. I mean, under that test, are you saying we should either vacate or just deny your petition?
Well, I believe that vacator is the remedy here, because nothing prevents the FRA from restarting the rulemaking process with information that is fresh and available. And I think, based on the circumstances that exist, this is a rule that is.
I understand the argument, but I just want to know if you are also making an alternative argument, and then I'll get out of the way here. Assume that we conclude that vacating is not the appropriate remedy, and assume that we are inclined to sua sponte, even though you didn't ask for this, remand, maybe on the fatigue management question, without vacating. Is it your position that we should not sua sponte remand, that instead of that, we should just deny the petition?
Well, if that were the case, we would welcome the sua sponte action to remand for further rulemaking, if that's what the court decides is appropriate.
And I didn't mean to monopolize the questions here, so I'll stop.
Mr. McKinley,
Go ahead.
How do you read the statute? I mean, moving to the fatigue management plan, do you think it would be lawful for the FRA to accept a risk management program that did not include a fatigue management plan?
Well, I think that goes to kind of the heart of the issue of what we argue with the fatigue management plan, is that Congress mandated that fatigue management plans are required components of risk reduction plans. And I would argue, and I put to the court here, that a risk reduction plan that does not have a fatigue management plan doesn't comply with the mandate of Congress. Hopefully that answers your question.
Well, but what if that plan, I mean, is there anything in the statute that requires all of those components to be approved by the agency at the same time?
Right.
Well, I would say that there's not anything that requires it to explicitly to be all approved at the same time, but I would point to the subsection in the RSIA where the fatigue management plans are included. It's a required component. So then the question becomes, I believe, at what point then are fatigue management plans to be then included in risk reduction plans? How long are we to go with risk reduction plans that do not have fatigue?
So that claim though isn't yet ripe, is it? Right. So if, for instance, the agency begins accepting these plans, or say we call them partial risk management plans because they don't have the fatigue management component, wouldn't your claim then only become ripe at the point at which the agency is, regularly accepting these risk programs without a fatigue management plan?
Well, Your Honor, I would say that at this point, the development of risk reduction plans is now currently ongoing. This is the process. They are to be submitted by Class 1 carriers August 21st of this year. So that development is currently ongoing. If you're suggesting that we would have to wait until plans are submitted for review by the FRA and the FRA then approves of these plans, in order for the action to be ripe, I don't know if I necessarily agree with that, because I think that the final rule is clear. And the FRA has stated its intent clearly that they're moving forward with this without the fatigue management plan component at this time. And that is how the process is going to move forward. And the FRA has indicated that they're doing a separate rulemaking with fatigue management plans. They issued the NPRM for that, I believe, on December 9th of 2020. But based on the timeliness of how long it took the FRA to issue a final rule with the risk reduction plan, I think we could be looking at a period of years without fatigue management plans.
How much time between the end of the comment period and the final rule?
The end of the comment period, the FRA had reopened it twice. I believe the comment period ended, I hesitate to say a specific date, but it was mid-October of 2015. And then the final rule was issued on February 10th of 2020. So that's more than 4 years and 2 months or so.
Okay.
And I guess we discussed, well, I guess I'm into my rebuttal time, so I guess I'll reserve what's left.
Okay. Do my colleagues have any further questions? No?
Not me.
Okay.
Well, thank you.
Thank you. Ms. Mundell?
Good morning, Your Honors. May it please the court. Amanda Mundell on behalf of the respondent agencies. This petition should be denied, and I'd like to start by responding to two of the points that petitioner has raised today. The first is with respect to the remedy that they've requested. As the court's questions suggest, vacatur here doesn't make sense as a practical matter. And it also is a remedy that no court has ever ordered with respect to delayed agency action, at least as far as when a statute doesn't have a penalty for noncompliance, which is exactly the case here. And I think, as Judge Edward points out, if it were really up to the courts to vacate a rule every time an agency misses a statutory deadline, there would be vacatur constantly, and it would stymie and bottleneck agency operations even further. And I think the point is underscored by the fact that, petitioners have suggested an argument today that, part of the reason why maybe vacatur makes sense is because the rule might have been relying on stale information. But the only example that they've now offered is a part of the rule that they haven't even challenged, which is about positive train control. So even that doesn't serve as a basis for vacatur here. I think at the end of the day, this is a rule that unfortunately took several years, but it wasn't the result of the agency thumbing its nose at Congress or flouting the congressional, requirements to attempt to make this rule in a timely fashion. This is a rule that is, massive. It involves several components, meetings with stakeholders, and the agency wisely acknowledged that reopening the comment period would have been necessary, that several public hearings would have been required to push this rule out. And ultimately, we do have a rule that I think petitioners agree needs to exist in some form. So vacating it, bringing us back to the status quo where there weren't extensive regulations in this area.
Ms. Mendel, let me ask you about the performance-based standards, which your opposing counsel didn't have a chance to touch on. There's nothing wrong with performance-based standards, at least in terms of what the statute allows, what APA would allow. But I had a hard time finding out what the standard is in this performance-based standard. And so I have some concern that the standard is so non-specific here that it's a standardless standard. So can you help me with that a little bit? And maybe as you do so, I'd be curious to know what precedent you would recommend I read where a court finds not arbitrary and capricious a standard that is as non-specific as your standard here.
Well, respectfully, Your Honor, we don't think there's a non-specific standard. I mean, Congress's mandate here is quite broad to reduce safety hazards and safety risks on train operations. And so to accomplish that objective, the performance-based aspect of this rule is first requiring railroads to identify those safety objectives on their systems. So perhaps some railroads have issues with derailment. That would be an objective that they would want to achieve under this rule would be reducing derailment. Other railroads might deal with more environmental-based hazards. Maybe other railroads deal with electronic or technological issues. So the rule puts it at first, at the first step in the railroad's corner to identify those objectives, and then requires them to identify a process or a system of steps that can address those objectives and mitigate those risks.
And in terms of those objectives, I mean, how would anyone ever know if those objectives are enough? So like, let's say that a train has 500 of a specific type of infraction per year on average over the past decade. And they set a goal of improving that so that they now only have 499 of those infractions per year going forward. I mean, would that satisfy the performance-based standard? And if it wouldn't, why wouldn't it?
That's a good question, Your Honor, and I think there's two responses to that. I think at the first, we have to take a step back and realize that this is an iterative process that isn't just fixed in stone. So the railroads are not just setting objectives, attempting to meet those objectives, and then never addressing additional safety risks to begin with. It might well be that when there are 500 infractions, reducing that down by one is actually a significant improvement. But this rule wouldn't just require them to stop there. Railroads are constantly required to address additional risks on their system. And the second aspect of my response to your question, Your Honor, is that we know that this would be, a good step to take because this is a collaborative process. The rule envisions collaboration between FRA, railroads, and other interested stakeholders, including petitioners here, including labor unions. And labor unions have the opportunity to raise these additional concerns both to the railroads and to FRA, so that FRA is aware of what risks exist on these systems and how best to address them. So I don't think that there's an oversight problem there.
What's the difference between non-binding guidance from the agency and your standard, which is purportedly a legally binding standard?
Well, Your Honor, this performance-based standard, this type of rule, requires these railroads to put together a plan that have objectives and certain processes in there that the agency is going to approve, and it requires periodic audits. So it's not as if the agency just sort of gives them a standardless guidance and railroads are off on their own to implement these programs as they see fit. Railroads have to do their own internal audits, and FRA has to conduct periodic audits under the rule. And if there is no compliance with the program, or if the railroad is consistently falling short of its deadlines or an implementation schedule, the statute itself authorizes the agency to seek civil penalties for that. So I think there's...
But I guess when would they seek the civil penalties? Is it a bad faith standard? These railroads are supposed to do these internal audits and figure out what's not terrific, and then they make some reforms and they set some goals. And if they are doing that in good faith, then they don't get penalized by the agency. And if they're doing that in bad faith, they do get penalized. But is it a good faith standard?
Your Honor, I don't think the standard is a good faith standard, but candidly, I think this is a case-by-case determination when if a railroad consistently is falling short of their obligations under the plan. But what I can tell you is that, again, this is a collaborative process. The agency is consistently reviewing these plans. The railroads are consistently updating them and implementing additional measures to address new hazards or new risks. And the employees themselves have the opportunity to flag any areas of concern for the agency in the course of the review process.
Okay.
Ms. Mundell, if I can ask you, so if we were to accept that the agency can promulgate the fatigue management plan separate, right, from its risk reduction program more generally, can the agency accept the risk reduction programs without a fatigue management plan under the statute?
Absolutely, Your Honor. And this was the second point that I wanted to raise in response.
Even though they're required components of such a program?
Absolutely. And I think, Judge Rao, as your question to petitioners suggested earlier, there's nothing in the statute that prohibits the agency from implementing Congress's mandate in a series of steps to first require risk reduction programs that have certain components and then to require an additional component. And there's nothing in the statute that prohibits or requires even railroads to implement all of these various components at the exact same time. And here it's well within the agency's discretion to first promulgate a rule addressing components 1, 2, and 3, and to add an additional rule addressing that last component. And just for what it's worth, these fatigue management plan requirements, once there is a final rule on fatigue management, will automatically get incorporated into a railroad's risk reduction program. So they're not, it's not as if railroads are ignoring fatigue management issues altogether. It's just that this part will come later.
So it's only a matter of time. So do you agree that if, say, in some number of years, the agency did not have a fatigue management plan and these programs were regularly getting approved without fatigue management plans, that would at some point be contrary to law or ultra vires or?
Well, I think petitioners might try to bring an action to compel agency action, which unlawfully withheld or unreasonably delayed. But here, of course, we have a rule in the process. The comment period has closed as of about a week and a half ago, and there's really no reason to expect the agency not to work diligently to issue that rule. I think it's worth pointing out that fatigue management is a much more discrete area than risk reduction programs, which involved a number of different concerns and moving components. It's also an area where the agency has extensive experience. So, I think it would be difficult to expect a rule to issue, right away within the next few months, because of course, review processes take time, but I would be surprised if a rule took an extensive amount of time in light of the fact that this is just the last piece of the puzzle here.
Okay, that's helpful.
Your Honors, if there are additional questions, I'd be welcome to answer them.
Do my colleagues have any further questions? No? Okay.
Thank you, Your Honors. We just ask that the petition be denied.
Thank you, Ms. Mundell. Mr. McKinley, we'll give you 2 minutes. You're muted.
I think you're on mute.
My apologies. Just to address briefly a few things that were said. With regard to fatigue management plans, the respondents suggest that they're allowed to address this matter in a series of steps, partial compliance, 1 step at a time, however it's been defined. And I would like to point out, though, that there is a requirement, though, that the FRA is required to explain why the problem should be treated this way. The FRA has not put forth any explanation for why there needs to be a separate rulemaking for fatigue management plans. And in fact, I think the record really cuts against their argument that our FRA submitted the fatigue management plan issue to the RSAC working group, it's called, in 2012, which then passed on its recommendations then. And then the FRA has not taken any action since until December 9th of 2020. And in the final rule, they simply state it should be addressed in a separate rulemaking. Well, why couldn't they be addressed at the same time? And these are just speculative questions because we don't know the answer because the FRA hasn't provided any sort of explanation for that. And to my last point, I guess, with Judge Walker, you raised a good point with it's a non-specific standard, and the FRA made it clear that it was particularly concerned with the financial burden on smaller railroads versus larger railroads when it comes to developing and implementing these plans. Now, but I think the final result, Judge Walker, as you said, is that this is a very non-specific standard. The FRA indicates in the final rule that it has the ability to scale down the rule 60%. They don't explain how the rule can be scaled down. When you look at subpart B of the final rule, there is no explanation in any way of how the rule can be scaled down. So I think what we have is a kind of ill-defined minimum standard that applies across all railroads. And
Don't the standards have to be approved by the FRA?
Well, yes, Judge, they do have to be approved by the FRA, but I would also point out that the final rule doesn't contain any sort of real process for how these plans are to be approved. The FRA is fairly silent on that. It seems to be, I think, as respondents stated, a sort of case-by-case basis. And that's not really a useful a rule here. This is, as I think Judge Walker said, it's more guidance than anything else. And I don't think, in this case, railroads necessarily know if they're going to comply, if they submit something to the FRA, if it'll be approved, and how exactly that process works. It's not defined in the final rule. And I'm into my time. If there's any other questions, I'd answer them. If not, I'll just ask that the rule be vacated.
Thank you, Mr. McKinley. This case is submitted.
Thank you.
This honorable court is now adjourned until Wednesday, March 10th at 9:30 a.m.